want to state it that I instructed my previous lawyers, who was Mr. Duplessis and Mrs. Annelien van der Heerwe, that I did ask to launch a recusal application for your recusal several times through all the court proceedings, but they didn't for some reason.
And the court about the attitude of the court towards the defense and the attitude of the court towards the witness. Because that will also constitute unfair trial.
What's the attitude now?
No. Even that, I don't want to go back to the records, my lord. I'm just checking when the witnesses are testifying, what is the attitude of the court. May I request the court to remain impartial? May I request if the court... Sorry, my lord.
I'm impartial. The only thing I'm doing in this court, I'm quoting the law as I understand it.
I've indicated earlier on when I was cross-examining Hall, I said after the examination of Gininda, I'm going to bring an application under section 371.
To 317.
317, the special entry.
317.
Yes, the special entry.
Yes.
Because of what I've picked up during...
okay, no problem.
Yes.
You know, the comment section is where I get some of the inspiration for some of my videos. And I was getting repeated requests to check out the Krejcir trial. And, you know, by checking it out, you also begin to see so many similarities. I just played you a clip of the late advocate Ngomezulu, and how he literally told the court that after the cross-examination of Brigadier Bongani Nicholas Gininda, that he was going to bring in an application for Section 317. I'll tell you what Section 317 is in a minute, but listen, that was deja vu to listen to, because the court this week was testifying himself, my lord himself was testifying on gold insertions in teeth. He was also, it is just absolutely shocking that my lord will assist a witness in the direction in which they should move their response when it comes to the insertions with regards to accused number 2, who medically it was found that he never had any insertions in his teeth. Ngomezulu said that he was going to launch that application because of the attitude of the court towards the accused and towards the defense. And we have seen it over and over and over again. Did Advocate Ngomezulu lie when he speaks about the attitude of the court? It is televised. We see it. We talk about it all the time. But my lord responds to Advocate Ngomezulu and says, I only quote the law. So somebody help me understand. How is he quoting the law when he speaks about piercings in a lady, even though a medical witness said otherwise, a medical expert has said otherwise? Ngomezulu unfortunately passed away untimely before he could even cross-examine Brigadier Gininda, before he could complete his promise that after that cross-examination, he would launch Section 317. What does Section 317 do? Section 317 of South Africa's Criminal Procedure Act 51 of 1977 relates to the procedure for an accused to request that specific questions of the law be reserved for the consideration of a higher court, typically after conviction in a trial. So this is what we see Krejcir do. He's about to be sentenced, and then he addresses my lord over there, and he talks about that he should recuse himself. But here, Advocate Ngomezulu was going to do it before the defense begins their cross-examination. So this continues to say, this is known as a special entry of irregularity or illegality, and is a legal mechanism aimed at addressing concerns over potential legal missteps during the trial. Key points of Section 317. Specific entry application. After the conviction, the accused can apply for a special entry to be made on the trial record, alleging that an irregularity or illegality occurred during the trial. The application must show that the irregularities involves a question of law. Point number 2, decision by the trial judge. The trial judge or presiding officer must consider the application, aka in this case, it would have been Judge Rata considering an application about himself, okay? And Advocate Ngomezulu would have been specifying, as he hinted here, his attitude towards the defense, the attitude of the court towards the defense and the accused. Judge Rata must listen to that, and then if the judge believes the claim has merit, they will allow the special entry to be made. If the judge denies the application, which the judge already told Ngomezulu that he wasn't going to approve it anyway, the accused may petition the higher court directly to review the decision. Once it's reviewed by a higher court, once a special entry is made, it is referred to a higher court, usually the Supreme Court of Appeals or a provincial division of the High Court. The higher court examines whether the irregularities had a material effect on the fairness of the trial and the validity of the conviction or sentence. Scope of Section 317. The provision is used to address errors of law, not issues of fact. For example, including improper admission of evidence. We see that multiple times. Misinterpretation of legal provisions. The gold insertion. Failure to follow procedural rules that could render the trial. Another example is the DNA evidence, okay? Now, the outcome, if the higher court finds that the irregularity materially affected the trial's outcome, the conviction or sentence may be set aside or altered. So the aim of Section 317 is to ensure fairness and legality in criminal trials by providing a pathway to rectify errors of law without waiting for a full appeal. It underscores the principle of justice and procedural correctness in South Africa's legal system. Wow. This is pretty interesting. Let me know your thoughts in the comment section down below. Let's continue. Let's listen to what Krejcir says about his judge over there. I'll be back with the rest of my commentary.
The newspaper article, which was on Thursday, 17th of February, saying that I'm voting to kill you, my lord. That you, my lord, are not biased, and even if you say that you are not, it's still my perception, and perception of other people in general, that you are biased, and justice must seem to be done. It's my perception to all the trial that you are the biased. I want to state it that I instructed my previous lawyers, who was Mr. Du Plessis and Mrs. Annelien van der Heerwe, that I did ask to launch a recusal application for your recusal several times through all the court proceedings, but they didn't for some reason. And they told me, yes, but for me, as I said, for some unknown reason, they didn't launch this application. I terminated the mandate after that, after the conviction sentence. That was one of the main reasons. I wish to call them in the box and that they can confirm what I'm saying. So I wish to call Mr. Du Plessis and Mrs. van der Heerwe to answer if what I'm saying is correct or not. After your conviction judgment, I appointed new lawyer as Mr. Nabis Provier. And my first instruction to him was to bring or launch application for your recusal as well from my sentencing procedure. But he refused as well. So I tried in person to bring this recusal application on the last appearance here for you, my lord, by myself, when I raised my hand in the court, at least for 10 minutes, and to draw your attention, but you completely ignored me, my lord. So I have been prejudiced, and I am able to show you why. So that's the reason why I'm asking for your recusal from my sentencing procedure. Obviously the main reason, because before I will start with all the facts, my application to you to recuse yourself from sentencing procedure is that you are biased, you are unfair, unobjective, dishonest, proven untruthful from record.
Just repeat: biased, unfair,
unobjective, dishonest,
dishonest,
and proven on the record that you are untruthful.
and proven to be untruthful. Yeah.
I have
What are the
noticed,
facts,
my lord, that
Mr. Krejcir?
you always have
Mr. Krejcir?
Yes, my lord.
What are the facts which underlie those conclusions?
It's facts from the transcript which I have with me. I would like to go through this transcript and go through all this unfairness or biasness from your side. My lord. Well, before we will go to this merits, I know you always asking for the authority. I brought some authority that I can bring the
Don't worry about the
refusal
authority
application.
now, Mr. Krejcir. Don't
Sorry,
worry
my
about
lord.
the authority now. Tell me why I'm biased. You've said because the newspaper published something, and you
Well,
perceive.
that's the last things I said in the newspaper. It's not something. It was in the media last week. It was another article that I'm plotting to kill you.
Yes.
And I want to
That found
categorically
that.
state it is not
Mr.
the truth.
Krejcir,
Yes, my
has
lord.
that found that allegation? That's the reason why you say I'm biased.
Well, it's one of the reasons.
What's the other reason?
The other reason is that you always treated differently my counsel compared to the state counsel in the whole procedure, whole the trial.
Yes.
Another reason is for you to putting not once your words to the state witness's mouth.
But what? My words.
Your words, yes. Through the questioning of the state witnesses,
Yes.
you did put several times your words to the state witness's mouth.
Yes.
One of the also main reason for you to have always those secret confidential meetings with the security people and police SAPS, who was whispering some stories and lies to you, to your ears without to disclose those fabricated sensational action stories to my counsel. For you to we started when we started on the 8th of May 2014. This courtroom looked like a courtroom. Right now, as you look this courtroom, it looks like a circus related to the security. Because as I remember, we started with the 3 security people. After was 5. After I don't know what happened. But right now, when I turn here, this atmosphere in this court is I don't know what to say. I don't know what is the effects why so many security people are here. Because as you said, there is the allegation that I wanted to kill you, but it's the same allegation that I wanted to escape. It's the same allegation that I had the gun in my cell and I smuggled this gun to my cell. It's the same allegation like every time before any court appearance in the newspaper, because the facts is that I never been charged for anything what this allegation said. Included all your security stories, what was brought to you, that I want to throw bottle on you and all this.
I don't recollect saying that.
Well, that was, my lord, I want to explain, you know, when I went down one of the appearance, I released this information to the 2 TRT guys, that I'm going to throw next time the bottle of the water on you.
Oh, you said that?
I said that because I wanted to know if this information will come to you.
Well, it never
It was
did.
only 2 TRT guys with me. The next appearance when I came here, you give the instruction that I mustn't take the bottle of the water with me to the appearance. This is what I received. So in my mind, I can see that this information clearly came to you without to disclose this information to my counsel, for example. Okay, there is a, sorry, for you, another reason for you to believe that I organized to kill you before, when this court start. From the start, you explained or you mentioned the issue what happened to you on the way home. Then some bullet of chipstone break your window in the car. So I had this was the first moment when I applied for your recusal, and I with my advocate and with my lawyer, and I said this judge can't continue in my case. Obviously, if he believes that I want to kill him, then it's not how it's supposed to be, because it's not true, obviously. And I don't know what happened with the story. It's on the record, but
What's on the record?
it's on the record that actually you mentioned that I will tell you exactly when we go
What's
to
on the record is that I said there was no evidence that you had shot me.
Yes, but you see that
And I still believe
already
it.
that you mentioning my name,
I beg your pardon?
already, my lord, that you mentioned my name in this case, in this, you know, in this situation.
So, did you guys pick up on those similarities with the SENZO MEYIWA trial? Or, am I just imagining everything? So, the 3 similarities that I picked up is that he says that my lord is always treating the state witnesses differently, okay? And he puts words in their mouth. Give me 4 examples, minimum 4 examples where you have heard Judge Rata do this, allegedly, Okay. And then another similarity is that he says you treat the defense counsel differently. Well, type 4 examples where you see this as well, where the defense in the SENZO MEYIWA trial are treated differently. And then finally, that he smuggled a pew-pew into his cell, which is similar to Bongani Ntanzi had a cell for an entire 6-month plus period, and nobody knew that he had it. But so what actually happened, in case you're wondering, with regards to the Czech fugitives' fair bid to have the judge recuse himself. So basically, the Czech fugitive on Monday represented himself in a South African high court as sentencing resumed in his kidnapping, attempted murder, and dealing in his Dagamizwa case. Krejcir, first of all, fired his lawyer, attorney Nadus Grove, before the sentencing could get underway. The Czech fugitive, who appeared with 5 other accused, then unsuccessfully tried to have Judge Colin Lamont recuse himself, alleging bias, dishonesty, and part of a conspiracy against him. Krejcir's co-accused, including Lupondo, warrant officers Samuel Modise Marubeng, George Jeff Ntaroane, Jan Lefu Mofokeng, and Siboniso Meyer. In October 2015, Krejcir was found guilty of ordering the kidnapping and torture of Begi Lukele, whose brother, Dr., had allegedly disappeared with 25 kgs of, stuff that he shouldn't have done. The doctor worked at a cargo company at OR Tambo International Airport. On Monday, with some degree of difficulty, Krejcir spoke in English as he gave evidence in mitigation of sentencing. Krejcir said Lamont should recuse himself because the judge had thought he had wanted to kill him after Lamont had had an accident on his way home. Why will I try to kill you? Why would you only mention my name when there are others who are accused? Krejcir said. He denied being involved in any plot to kill the judge. After Lamont dismissed the application to recuse himself, he asked Krejcir to tell him about himself and his responsibilities. Krejcir said he had studied for a degree in economics in his home country and came to South Africa in 2007. He said he has been married for 25 years and had 2 sons, a 6-year-old and a 23-year-old, who were deported from South Africa. Krejcir said he assumed his mother was looking after his other son and wife. Krejcir, who is 47 at the time, said he had millions overseas. Dressed in a white t-shirt and in handkerchiefs, Krejcir cut a lonely figure in the court where numerous armed police officers kept watch. State prosecutor Louis Mashiane said it had no objection, the judge standing down the matter to allow Krejcir to get a Czech interpreter and to bring witnesses. Judge Lamont took a short adjournment to consider Krejcir's request for a postponement. And so that's the Mail and Guardian. But let me know your thoughts in the comment section down below. Thanks so much for watching. Remember to like, comment, and subscribe. And I'll definitely catch you on my next upload.